Good afternoon, everyone. Thank you for joining our CLE on how to probate a will. My name is Kristen Salas. I am one of the mentor attorneys at the Dallas Volunteer Attorney Program. Those of you that are not familiar with the Dallas Volunteer Attorney Program, or DVAP as we call it for short, we are a joint program with Legal Aid in Northwest Texas, and our primary mission is to match low-income Dallas residents with a private pro bono attorney that will work on their civil case pro bono. One of the many types of cases that we get are people that need help probating somebody's will in order to be able to clear title to the house they're living in, or needing to clear out a little bank account that their relative has left them. So we are blessed today to hear from Melinda Hartnett to tell us all about how to do the probate of a will. Melinda is a partner at the Hartnett Law Firm. She practices primarily in probate litigation. She's a graduate from Hockaday School in Dallas and went to college at Hampton College in New York and received her JD from Fordham Law School. She's a member of both the Dallas Bar Association and the New York Bar. She's an active DVAP volunteer and also participates fairly regularly in the Bar None every year. She is one of our probate mentors, so when we have questions that we can't figure out, we always turn to Melinda to answer those questions. If you have questions as she goes along, feel free to use the Q&A feature at the bottom in the chat section, and we will try to get to as many of your questions as possible at the end of the presentation. So without further ado, I will turn it over to Melinda.
Thanks, Kristen. Hi to everyone, and thanks for attending the CLE today. I'm hoping technologically this will work out okay. Fairly new, but been practicing, and I'm also hoping I look at the camera so you don't see me looking down for all the presentation. I am going to be speaking on kind of the basics of probating a will. Hopefully a will you get to probate is fairly standard, but a lot of times they're not. So I'm going to go over some about what to look for, questions you need to ask, and how to move forward with the courts. So to look at the topics we're going to be covering, your first look at the will, the information you need to move forward with the probate, how to do a simple probate of a self-proof will, a simple probate of a non-self-proof will, issues you might be looking for, what happens after the will is probated, and then some tips for moving forward. Now, your first look at the will, gives you a pretty good idea of whether this is going to be simple or not simple. It's not always evident at the beginning, but sometimes it is if you look at some key ingredients to your will. Your hope is that you don't get a will like we had. Now, we do a lot of will contests, trust litigation, things like that. So sometimes we get some wills that aren't your standard wills. Here's one will that we had several years ago that we were fighting about, saying whether it was a will at all or not, and if so, which part of this is a will. Here the testator had done a holographic will that looked pretty good at the time, back in 1999, but then at some point scratched out, said it's not my will, and another pen on the side says, look at, changes the provision that it's making for the children, and was just a mess. On the other side of the paper, it got even stranger. So we have, this is not my will, but I leave everything to my wife, and arrows, and it was a big fight on whether this was a will at all, and if so, which portion was the will. And that estate was $17 million combined, community estate. So hopefully your DVAP cases won't have a will that looks like that, or any other wills that you get. Now, your first look at the will when they bring it in. First thing I do is to look at the signature and the date. Get an idea of, does the signature look shaky? That doesn't mean it's not a good will. Is it have even an X? Doesn't mean it's not a valid will. but it'll give you an idea. Does this look like something I should be concerned about, or at least ask questions about? And what's the date? Was this signed last week? Again, doesn't mean it's not a valid will, but you might want to look for some red flags and follow up with some questions. Next, I look at the witnesses and the notary. Are there two witnesses? Is there a notary on the self-proving affidavit? You don't need a notary on the will portion for it to be a valid will, just on the affidavit. But are there two witnesses? Are the witnesses beneficiaries in the will? You'll want to look at that as you get to the next portion of what I suggest you look at. But you want to see, does it look like a family member? Does it look like somebody unrelated? At the same time as you're looking at this, you might get an idea of whether it was executed in an attorney's office or the will was prepared by an attorney. Again, it doesn't mean it's perfect, but it might give you a little more comfort knowing they saw somebody. This wasn't something a beneficiary prepared or the testator prepared themselves. Next, I go to the specific and residuary bequests, and I go to the residuary bequests pretty quickly. Who's inheriting this property? Is it the spouse? That's pretty good sign, but you need to ask some questions. Are there children that aren't the spouse's children? What do the specific bequests look like? Are there any issues with that? Is there anything that's not mentioned? Is there anything that's not included in the residuary? Sometimes they use different language in the residuary rather than saying all the rest in residue. So just get a quick look at that to get an idea of whether you have any problems. You want to look at the executor provision. Does it name an executor? Does it name an independent executor? Who is it that's named, and is that person still alive? Are they willing to serve? Those are going to be things you're going to look at more later, but I quickly look at it when I look at a will before going through everything. But finally, I do go through the entire will because you never know where there's some crazy provision added. I've had a will where it said I leave everything to my children, and then on the last page or near last page, it says children does not include John, one of the children. So you've got to take a look at everything just to make sure you're not missing anything that would change the disposition. Finally, I look at the self-proving affidavit. Was this, did they sign a self-proving affidavit? Did the two witnesses sign it? And was it notarized? If so, that changes the steps you need to take to probate the will. It is possible, there is now a one-step signing where they can essentially just sign the self-proving affidavit. It does have to have some additional language, which is in the estates code, but then the testator doesn't have to sign, or the witnesses don't have to sign twice. They can just have one signature altogether and it's still self-proving. This is generally what a self-proving affidavit looks like. It's a statutory form. The statute says in substantial compliance with this form. So if it's not verbatim, that may be okay. But if there are any significant changes or even specific changes, your court could have a problem. And some of that will depend on the court you're in front of and the judge. And sometimes you don't find that out till the hearing. So it's good to look at it, to know what your problems are, to know, is this in compliance? Is it not? Or do I think there might be an error, so that the judge isn't pointing it out to you, although that does sometimes happen. All right, once you've looked at your will and you think, oh, this is a will I'm going to move forward with, and we can try and get this will probated, you need to get some information from the client. Obviously, you need the date of death. That's something that I also ask when I'm looking at the date of the will to know, was it signed close to death? So maybe the will was signed 2 years ago. And so you think, well, 2 years, that's probably enough time. But maybe the decedent died a few days after that, and they just haven't probated the will. So a lot of times it's one of the first questions I'll ask early on to get an idea of what we're looking at. You need the decedent's date of birth. That goes in the application as well. The decedent's residence. And this is important because it can direct what court you file your probate for. Both the decedent's residence and where the decedent died can have a bearing on that. It doesn't necessarily determine there's a list in the state's code as to how you decided what court has venue, but knowing the decedent's residence, which goes into the application, as well as where they died, are important things for you to know. You need to know the applicant's residence as well. That goes in the application. This was added probably now it's been a couple years. The last 3 numbers from the social security number and driver's license for the applicant and for the decedent if you have it. Sometimes they're elderly, so they weren't driving any longer. So in that case, you don't have to put it. But otherwise, you put the last 3 numbers of both of those. It's not a bad idea to find out who are the heirs at law. Who will inherit if this will is not probated? And if it leaves it to say 1 child, what are the other heirs at law going to say about this? Particularly in a DVAP case where there's not a lot of money, you don't want to get into litigation. You need to have a good idea of where am I heading with this? Is someone going to fight it? It goes back to how does the will look? Even if the will, you're not sure about the date of the will and when the person died, if the heirs at law inherit under the will, you're probably not going to have a problem. So having an idea of the heirs at law agreeing with this disposition can help prevent some problems down the road. Then the executor qualifications. Assuming the will names an executor and assuming it's independent, you want to find out if your executor is qualified. And if it's not the first executor, well, who's the successor and are they qualified? We used to just say, I've discussed with you what it means to be qualified and not disqualified, and you believe that you are qualified. But now the courts like you to ask, some of the courts in Dallas, they do ask the qualification questions. And it's not difficult. It's something that happens quickly. Here are the main ones that we ask about. There is no set standard for what makes a person qualified or disqualified. It's a question of whether they're suitable. So these have kind of become some of the standard ones that could be an issue. It doesn't mean that every one of these is an issue. So you find out if they're over 18 years of age, never declared of unsound mind, don't have any felony convictions, no misdemeanors involving moral turpitude, such as stealing, no bankruptcies, no claims against the estate, and the estate has no claims against you. Again, if they have filed for bankruptcy back in 1990, that might not be a problem for the court, but you would want to know the answer to that question and make sure the court knows and kind of flesh that out if you need to. I have had that happen where it was 30 years ago and the person still got appointed. So there's no factor, well, there's not that there's none, but none of these factors are necessarily disqualifying issues, but you want to be aware of it. Most importantly, you want to try to remember to ask these questions before you apply for that person to be executor, and particularly before the hearing. If you get to the hearing and then you say, it's true, you don't have any felony convictions, and they say, well, there was this one 2 years ago or something like that, then you look unprepared for the court. It may happen, people forget, or more often, a witness says, oh, I had forgotten about that one, or, oh, I forgot about this bankruptcy. I didn't know you needed to know. But you still want to have done your due diligence as much as you can beforehand to know what you're going to be faced with. So assuming that you have gone through all this information, you are ready to file your will for probate, what are the next steps? We're going to go with first a self-proven will. So they've signed the affidavit. Two witnesses witnessed the will. They witnessed and signed the self-proving affidavit, and the self-proving affidavit was notarized. At the hearing, you need one proof of death. This can be an interested witness, someone who is inheriting under the will, somebody who's related to the testator. It can be also the executor, which often happens. You need to have an oath for your executor to sign, saying that they will abide by the terms of the will. You'll obviously need your order probating the will, which is what the court will sign that will make all of this official and allow you to get your letters testamentary once you have the oath and the order. In court 2, there may be additional proof information. So court 2 has developed its own questions that it likes to have in writing. So for example, the qualifications of an executor. Some courts will allow you to simply ask the person those questions. Court 2 wants you to have them in writing and the person to sign that just like a regular proof. And if you know those questions, you can incorporate them into one proof. So you still just have the one proof. Alternatively, you can do it as 2 separate proofs. And then if sometimes these probates are heard by the associate judges, we have 3 associate judges now in Dallas County. Each court has its own. And simple will probates are a common thing for them to hear. If it's going to be assigned to an associate judge, you need to sign a waiver of de novo hearings. So that gets e-filed. A lot of times, well, with some courts, you know ahead of time and you actually set it on their docket. And with other courts, you find out closer to the hearing and they'll say you need to e-file your waiver and you can get that signed and e-filed. All right, here's what a proof of death looks like in a simple will prove up. And it's very standard. There's nothing that you need to add other than what you see here, unless you're dealing with qualification issues. At your hearing, you call your witness and you can literally go straight down this proof and ask leading questions. This is assuming your will, you're not foreseeing any problems. This process can be really simple and streamlined. So I'm going to give you an example of how I would ask these questions. I will have called my witness. The judge will have sworn the person in. This is me, actually, as it appears as the witness. So I would say, Ms. Hartnett, is it true? Well, first I would say, Ms. Hartnett, are you the, daughter of John Smith? Yes. Okay, is it true that Mr. Smith died on September 1st, 2019 in Dallas County, Texas at the age of 80 years? Yes. Is it true that 4 years have not elapsed since decedent's death? Yes. Isn't it true, or is it true that decedent was domiciled and had a fixed place of residence in this county at the time of death? You can do that for all of these questions, all of these points. On number 6, we get to the executor. It says the independent executor named in the will is not disqualified by law from accepting letters testamentary. I would say to my witness, you and I have discussed what it means to be qualified and not disqualified. Is that correct? Yes. And you believe that you are not disqualified by law from accepting letters testamentary. Is that correct? Yes. You are over the age of 18. Is that correct? Yes. You have never been convicted of a felony. Is that correct? And I would go through those qualifications. If you're in court 2, and if you want to do it in the other courts, you can include those qualifications in your proof and just continue down just like you're seeing here. So that's the simplest way to streamline this process, to ask the question, to not have your witness who may be nervous about being in court for possibly the first time think, oh, when did the decedent die? Oh, when is the will dated? You'll have it right there and they can answer yes, no questions. Here's the proof addendum qualification for court 2. I don't know how current this version is I'm put on here, but it has the qualification questions that you would want to include in any prove up in court 2. Often if there's a change to these, the court may have a form there that you can use to ask the questions and to have your witness sign. Now, we have had, like I said, done a lot of will contests. And so we have a few videos we'd like to play for people. And as you saw the street will before, just to give you an idea of what can go wrong with a will signing and why do we care? Why are we careful? Okay, let me see if I can get this to play.
A whole big bunch of stuff. And we decided that it would go into a residual trust after you make all these other gifts to like MD Anderson, Texas Christian University, Scottish Rite Hospital, the University Hospital Foundation in Oklahoma. Okay. Okay. Now, it says in here, let me see if you, wait, let me see if this is okay with you. It says fees and bonds, that there will be some fees for managing this estate. Is that okay? Okay, like the bank will charge or something like that. Okay. Now, it says here that on the 30th day, says Cleo Mason Hamilton. And you need to make an X right down, not up there, right here, right, put your pencil right where mine is. And make it one of those big X's there. I'll make an X. That's Cleo, C-L, just give me an L. E, O. Okay, that's pretty good. Want to try that Hamilton? Yeah. Try Hamilton. H, A, remember it's A comes or something, okay. M, H-A-M-I-L-T. Can you do an O-N on that now? O-N. Okay, that's fine. That's good.
Okay, so that was one of our will contests with the capacity and undue influence. You know, the beneficiary had the woman signing at 9 o'clock at night. She was exhausted. She wanted to get it done and over with. She's summarizing the will. She says, sign with an X. The woman signs with her name. She's having to spell it. I mean, you can see the problems. And it's one of the reasons the court does take care in probating a will and want to know the facts and why you look for issues in your will. All right, so moving on to the simple probate of a non-self-proven will. So say you don't get your affidavit signed at the end, or there's for some other reason the affidavit is insufficient. You have the same proof of death as you did above. So you can have your executor or whomever testify to a lot of the basic issues about death and about the will. But you also need a proof by a subscribing witness or other witness. And when I say proof, that means you need another witness. They need to be able to recognize the signature on the will and know that that's that person's signature. If it's a subscribing witness, if you can find them and know who that is, that's great. If not, you can have another witness to testify to those same facts. And they sign their own proof as well. You will still have an oath. Assuming you get an executor or an administrator, you will have an oath that you prepare. And then you have your order probating the will. That's what you always need. That's what allows you to get your letters. And that tells you who needs to take the oath because they're the person who's appointed under the will. Here's a proof that's used for a subscribing witness. So if there's someone who witnessed the testator signing, their proof is a little simpler. And they can testify to these facts. And even though it's not bulleted like the prior one, I would use the same method to question my subscribing witness by using leading questions on each of the sentences that you see there. Alternatively, if you don't have one of the subscribing witnesses, then you have a proof of the decedent's handwriting and signature. And they can go through all those points and then state that they're familiar with the handwriting, and they identify the handwriting on the will. They do have to be an independent witness, so you can't have a beneficiary from the will sign one of these documents. So what are some other issues? We talked at the beginning about things to look at when you first get the will, and looking at the date and that kind of thing, finding out who the beneficiaries are and any issues you may have with that. But what else do you need to look at? One of the most important things is whether you have an original will. And this can be, may not be as obvious as you'd like it to be. Even if you have blue ink, what appears to be blue ink, now with color copiers, it can be a lot more difficult to tell if you have an original. If all you have is a copy and the beneficiaries have no hope of finding the original, you can still probate that. You have to plead some additional facts. There's a presumption that it has been revoked if you don't have the original, but maybe that's not at all what happens. Maybe it was lost in a fire, for example, or there was a move and it can't be located. It's not unusual to be probating a copy of a will. You just need to know it so that you allege the facts in your application for why you can't find the original. You also have to give notice to all the heirs at law. So in a normal probate, application to probate, people are surprised to find that you don't have to give notice to anyone. There's a notice goes out that's issued by the clerks, but you don't have to serve any of the kids, the spouse. That doesn't happen until after, if they're a beneficiary. So wills can get probated without any notice to anyone. We deal with a lot of that in our will contest, where someone tries to go down as quickly as possible to probate a will that's maybe a little bit questionable. And I don't think I didn't talk about this before. Once you file your will, it has to be posted. You have 10 days. The Monday following 10 days is when you can first get a hearing on that will to prove it up. Now in Dallas County, it's a busy county. There's a lot going on. You are likely not going to get a hearing the Monday following 10 days. You also have to wait for things to be posted and it takes some time. In some smaller counties, they have open prove-ups where you can show up on Monday and they just probate wills most of the day. But in Dallas, that's the first you can do it, but you're probably looking at a longer period of time. It just depends on the court's docket. Anyway, so with with a copy of a will, you have to give notice to all the heirs at law, because they may want to come and say, wait a minute, that will, I know that will was revoked. Plus, if it's not a valid will, they'll inherit. So that's an additional step that has to be taken if you have a copy. Talking about whether it's difficult or not knowing that it's a copy. I know we have here filed a will for probate believing it was the original, and one of the associate judges has machinery to look at the will and determine whether it's an original or not. There's a way with photographers or other way to look closely at the signature and get a better idea. So it's not something you're just going to slip by the court and hope that they don't notice. It's a color copy, so you'll get by it. They really do need to know, but there's a way around that if you don't ever find the original. Perhaps your will was, your decedent died more than 4 years ago. A will is supposed to be probated within 4 years of death. It is possible to still probate that will. You have to allege good cause. Why is it that this was not probated? And you need to put that in your application to explain why. One of the problems with this is that is applied differently all around the state. Sometimes it's enough to just say, I didn't know I need to. Sometimes it's been enough that one person didn't probate it, that person died, and the next person named executor says, well, I didn't know that there was a will and it needed to be probated. So it just depends on the court. You can do research on that if needed, but it just varies. You need to make sure though that you have the allegation application, or else you're not going to be able to get it done. The main thing is you can't get an administration within the 4 years. You can do what's called a muniment of title. So probate is a muniment of title. You don't have an executor appointed. You don't really have an administration. With a muniment of title, the document, the judgment works to transfer title. Title companies know if they go look at the real property records in Dallas County, they look at the probate records and can see whether there was a will probated. If you do this in another county, or if you do it in Dallas, but the person owns real property, say in Harris County, you want to file your order probating the will in the deed records in Harris County, and that will be sufficient to transfer title. It can work with bank accounts that you get your order and it says, this will has been probated and you can take it to the bank. Just sometimes they're a little more hesitant because it's not a procedure that I know of that is available in all the states. And as you probably know, if you go to the bank, they send your documents off to their legal department that may be in, Wyoming. And those people are trying to determine, is this valid? What authority do they have to transfer any of these assets? So anyway, if your will is beyond 4 years since the decedent died, muniment of title is your only possibility to get it probated. You can also do a muniment of title just because it's a simpler process, because you don't need an executor. Say it's just real property, and in DVAP, this would not be unusual. In DVAP cases, maybe there's just a house that you want to transfer. Then you can do a muniment of title. You don't have to have an executor appointed. You don't have to give the same notices after probate that you do in a regular probate, and you don't have to do an inventory. So I know a lot of lawyers who don't like muniment of title because they believe that at some point they're going to need an executor, or they may, and then what will they do? We do them fairly often, not just in DVAP cases, but in other cases. If everything looks simple, if all the bills are going to be paid, there's just the normal debt, the less utility debts and that kind of thing. Muniment of title is a much easier way to go. Figure out whether your executor is disqualified. We spend a lot of time talking about that, what the qualifications are. If your executor is disqualified, do you have a successor named? Can that person serve? If you can go down, just keep going down the list that's in your will. It may be that none of them are qualified to serve, and then you're looking at letters of administration or letters of administration with will annexed. In letters of administration with will annexed, you have a valid will, but it's none of the executors can serve. So you get another family member or another person who can be appointed administrator with will annexed. You have a valid will. You're not saying this is an intestate situation. So that is, you need the people to agree on it that are inheriting the property. So the court is not going to appoint independent executors or independent administrators if the beneficiaries don't agree. Let me restate that, because I said the court will appoint independent executors if it's listed in the will. Those people can go. There doesn't have to be agreement. But if you're going to have someone who's not listed in a will appointed as administrator, then you need to have the beneficiaries agree. Otherwise, the court will go with dependent. That's a whole different ball of wax. So you, with an independent, that's what you're hoping for. You have to have the beneficiaries agree. Some wills try to name an independent executor but fail. If that's the case, you're back to what I was just talking about. You need to get the beneficiaries to agree to an independent executor, and it benefits most people, if everything's above board, to have an independent executor. If you're concerned there's trust issues, okay, you may want to go with a dependent. In the DVAP case, that would be difficult. But otherwise, a dependent is cumbersome and expensive, and best for those situations where people aren't agreeing and there's trust issues. What if your will is not properly witnessed or notarized? Okay, the notary is just on the self-proving affidavit, so you don't have to worry about that on the will. What if you only have one will witness, but two on the self-proving affidavit? What if you have only one witness and then you have the self-proving affidavit was notarized, but just with the one witness? You can use the signatures from the self-proving affidavit to witness your will. So it makes it not self-proving, but whoever signed the self-proving affidavit can now be a witness to the will signing, including the notary. Assuming the notary was there when it was signed, the notary can act as your witness, but now you're proving up as a non-self-proven will. That just takes you into having additional proofs that we went over before. Finally, what happens if you have an ambiguous will? Say there's some terms that it's not clear who one of the nephews is, or a niece, or there's a misnomer or something like that. Well, then you really probably want to have the court address that. You can ask for a declaratory judgment, and it doesn't have to be a major proceeding, but the court can make that declaration. If you have an independent administration and your beneficiaries agree with what's going to happen, you don't have as big of an issue, because once the independent executor is in place, they can deal with who receives the property and how it gets distributed. Now, they could have a target on their back if they're going to go, ignore the will. That's a big problem and they'll be sued. But assuming everybody's on board, you can get written agreements to deal with the ambiguity. If it just looks like a typo or something like that, that works in an independent administration, not necessarily in a dependent administration. Finally, another kind of will that you could get, particularly with DVAP, but as you saw before, we had in a $17 million case, is a holographic will. So a will that's all in the handwriting of the decedent, and it can only be in their handwriting. If it is, the will doesn't need to be witnessed, doesn't need to be notarized. It could have a self-proving affidavit, but that would change kind of, whether you have witnesses or not. But that it can be a valid will, and it can be probated. It can name an executor. It can serve just like a normal will, typewritten will prepared by an attorney. Often they have problems, and it can vary from not naming an executor to not distributing all the property to not having a residuary clause. So you want to read those over carefully and make sure that it makes sense. Make sure that it asks for what it needs to. It can be a partial holographic will. It can only cover some of the decedent's property, which doesn't make it an invalid will. It's just you may then still be dealing with an heirship or something like that. One other thing I want to mention back on the muniment of title, if you're dealing with muniment of title and your decedent was on Medicaid, or you're not sure if they were on Medicaid, and that may be the case, particularly in DVAP cases, you want to find out if there's going to be a Medicaid recovery proceeding, if Medicaid's going to go after the estate. It's a MERP request, and you can go on the Medicaid website, and they have a form that you send asking if there's the person received Medicaid and if Medicaid will make a claim. And you want to have that because that will go into your application, and you'll inform the court of that so that they know this can proceed without any problems. There's no claims. For a muniment, you have to have no claims, no debts. So they want to know that you have that. All right, I think I have another video that you'll see this woman and the decisions that she's making or someone is making for her regarding her will. And there's two videos here.
That says that you give $25,000 to Kathy.
Well, I can.
Is that what you want to do?
I can. If you've got that down there, I give her money almost every month right now when I get my checks. But I will.
Okay, so you want to give her, now you said before that you wanted to give her $25,000.
All right. If you put it down, I'll do it.
Okay. You also said, now, do you want to give her anything else? Is that all you want to give her is $25,000?
If I've got anything else to give her, I'll give it to her.
Okay. All right. Also, Renee Guthrie. That says that you give $25,000 to Kathy.
Well, I can. Yes, he's not married.
Now,
He's just his youngest brother.
okay, now if Michael were to die before you, who would you want? Would you want it to go to his children or to go to Lee?
I'd want it to go to Lee, wouldn't I? Please?
I would say my children.
Well, would you not want his children to receive it? When we talked before, you suggested to me that you wanted his children to receive it.
You want me to say yes or no?
Well, okay, it's your decision totally.
Huh?
It's your decision totally.
If he would die before me,
Right.
I don't think that's gonna happen, so I'm not worrying about that.
The way we have it written here is that in the event that Michael dies before you, it will go to his children. Is that okay with you?
It's all right.
Okay, so hopefully you saw all kinds of issues with that will execution. The lawyer should have seen all kinds of red flags going on, starting with having a beneficiary in the room, but plenty other red flags. All right, so after the will is probated, whether it's self-proved or non-self-proven, you have to do 308 notices. It's 308 in the estates code. Those are can be sent by certified mail, and you get the green card back, return receipt requested, get the green card back. Far better is to get waivers. So these go to the beneficiaries in the will. If they will sign waivers, your life will be much easier. And it says that they've received, the documents, they've received the will, and there's a kind of language in the estates code that tells you exactly what it needs to say. And that way you get it. You don't have to worry about the green cards. With the post office, the green cards a lot of times don't come back, or you don't know who signed, and it's very difficult. So if everybody's getting along, hopefully you can email them some waivers and they will sign those, and you can move forward. You file those with the court. Once you have given notice to everybody, whether by certified mail or waivers, you sign a 308 affidavit, and it goes through and lists everyone who had to receive notice and that you gave them notice and how you did it. And you can attach the green cards if you need to. Oh, I missed that note above. Yes, 308 notices are not necessary in immuniment of title because there's nobody to give it. The executor normally gives them. Then you have to do an administration, an inventory, appraisement, and list of claims. This gets filed within 60 days and lists the assets in the estate and their market value. Usually for real property, we tend to do the Dallas Central Appraisal District value and just put that on there and note that's what it is. If it's cars, you can do a Kelly Blue Book value or CarMax value. It's not something you need to have appraised necessarily unless you're talking about some property that's very valuable. The list of claims is your claims the estate has against someone else. It's not debts. Debts don't go anywhere on the inventory and appraisement. That is only claims that the estate could go sue someone for, or for the return of some property. With immuniment of title, you do an affidavit of compliance that says, basically, I've done what I needed to do. The applicant signs that, and that can be waived if the only beneficiary is the spouse. But that happens at the probate, and it's a very simple form. So if it doesn't get waived, it's easy enough to sign that and have it filed. But basically it's saying, okay, I probated this in the counties that needed to, or I filed it in the counties that needed to be filed. And another thing on the last one, you need to do the notice to creditors if you have an administration. All right, some tips for other things that might help you. The probate manual, the probate section did a probate manual years and years ago that gets updated now, and it is so helpful and is forms we use all the time. If you take a DVAP case, my understanding is you can get this for free. So you contact the probate trust and estate section of the DBA, and I saw it, I Googled it and it came right up. And it will have forms for probate, for heirship, for guardianship, and I always start with that form. There are changes by the courts, but you can figure that out as you go. It just gives you a nice starting point to make sure you don't miss anything. Use the court staff. They're not going to give you advice necessarily. They're not going to walk you through everything, but if you have a question, sometimes you can call and say, what's the court's preference on this? Particularly with Zoom hearings now, it's new to all of us, or was 9 months ago. You can call the staff and see if somebody can answer your question, or you can always call another probate attorney who has done this quite a bit, and they can tell you, where they think things were the last time they were in court. Things do change. What the courts want changes, questions they want, or steps they want you to take do change. So there's always some kind of surprises here and there. The state's code, here are some of the provisions that you'll want to be familiar with and you'll want to look at when you're probating wills. Remember to use your proof for your questioning. You do not need to start from a blank slate. You can use that proof, take a copy with you, assuming you're in person, because your witness is going to sign the other one, the court's going to have one. You want to be able to go down the list for yourself. Most importantly, know the court, be prepared and prepare your client. Like I said, the courts are different. Our 3 probate courts are different. Our associate judges are different. So as familiar as you can be will help you. Make sure your client has read through the proof. You've made changes if you can. They can be interlineated there, but you obviously want to limit that as much as possible. I have one last video for you that shows, what happens when your decedent is going off script. You shouldn't have this in your practice if you're doing a will, but this will show you when someone has to fix the situation.
American brands, and I had rather not have the furniture moved out of the house at all, because I want to give it to the income from the stock.
So there, they just had to start over. The decedent wasn't complying with what they thought should be being said there and what they'd probably prepared under the will. But anyway, that kind of gives you the basics of what you need to do, and hopefully your DVAP will be one of the simpler ones and self-proven, and everything can go your way with that. That's the end of my presentation, but I've seen there are some questions popping up, so I'm going to try to stop my screen share, and hopefully that is all working. I see chat and Q&A, so I'm going to do my best. Okay, what filing and prove up hearing procedures have changed because of COVID? Well, I will tell you that the clerks have been pretty slow getting things accepted. It's getting better. They've gotten caught up a lot, but it takes more time. So be prepared for that. You need to e-file all your documents, your proof, your order, your oath. All needs to be e-filed. If it's very late, if you're pretty close to your hearing, you might email it directly to the court as well, because they need to have those. I believe that the courts are all allowing the witnesses to be separate from you. They don't have to come to your office. If they are in person on Zoom, they don't have to have a notary. But if they do not appear on Zoom, if it's telephonic for some reason, then they'll have to have the document notarized. But I think the courts are running pretty smoothly now on Zoom. Most of it is the same. You just need to get it filed ahead of time. So I hope that answers that question. Can you add those provisions in the proof for other courts, even though they don't require it? Absolutely. I mean, is more information, but especially for the qualifications, you're asking those questions anyway, and it's a way to remember them, if nothing else, because you're going to go write down the proof anyway. You'll have them there for yourself. So there's no problem with adding those provisions. Ray, bank account. If you know the bank but don't know the account number, what do you do? Well, I'm assuming this is a question for the inventory. I'm not sure, but assuming it is, your executor can go to the bank. If you have immuniment of title, hopefully the heirs go and the bank will look it up and get that information for you. If you're the executor, you have the right to all the information. So you go and give them they need the letters testamentary. So after you've probated your will, you order letters testamentary. That's the official document that any entity needs to give you your information and let you take control of the assets. Every now and then banks can be difficult. They can ask for things that they don't need. Either your executor can provide those things or can make it more difficult. I do sometimes, just because I know they don't need that document. So I say, no, you don't need it. And here's my letters, and try to push it through that way. But they should then be able to give you all the banking information that you need. A bigger challenge is if you don't know of any banks, you don't know where they banked. You can wait for the mail to come and hopefully get statements. And sometimes I've gone to, when I've been administrator, gone to banks in the neighborhood and just asked if they have accounts. Do you recommend amendment of title case for out-of-state property? If you're talking real property, you're going to have to do a probate in that state, and it varies how they do it. Sometimes it's an ancillary proceeding and you just file your documents there. Sometimes you have to have somebody appointed to have authority there. That's for real property. If you have personal property, hopefully it's not an issue. You know, if it's bank accounts, shouldn't be an issue, but say it's a bank that's only in Oklahoma, and they don't know about our amendment of title, you know, you might run into an issue there. It just, you know, it would really have to be some entity that's only in that state that would have a problem. I don't really see that as an issue, but depends on the size of the estate, you know, whether you want to just go ahead and get an executor. There are more hoops to jump through, but they're not very onerous. Process of probating a typed will with fill in the blanks that were filled in handwriting. My understanding is that would need to be witnessed because you don't know when those blanks were filled in. You don't have any idea of really what went on. So my understanding is the holographic will must all be in writing, and even if it's not, can you tell what the will is saying with just the holographic part? Or do you need those typewritten parts? If you need the typewritten parts, I think it has to be witnessed. I don't know where I feel like oh, she's moving them. Okay, what about holographic wills that are illegible? Are those still probated? You know, it depends. How illegible? Is there somebody who can read it? Do you need expert testimony? You know, you're going to have a much bigger issue there. Do you have the heirs at law that are in agreement? Can they agree with what it says? Will a court believe that that's what it says? You've got a lot of issues. So hopefully someone can tell you what it says, and hopefully it's nothing drastic. It's not leaving it to the next door neighbor instead of the kids. I don't have the link to the forms. My understanding is you call the probate section, the person in charge of the probate section, probate manual, and speak to them. There may be an online request, but if you're going to get it free for taking a DVAP case, you may need to call them. So I don't have that information, unfortunately. How long does a typical simple probate take, and what kind of court costs should be expected? Good question. Simple probate, it depends on the county. In Dallas County, it could easily be 3 months just because it's taking a while. I don't know what right now when they're setting, but sometimes it's months out. If you're talking Collin County, it can be in a month. They'll have a hearing so fast that you'll be like, no, I need more time to get prepared. It just kind of varies on the state of the county. Right now with COVID, I tell people it's going to be a while. In Dallas County particularly, because they're just backed up and they have so many cases to deal with. What kind of court costs should be expected? The filing fees are less than $500, maybe $300, I'm not sure. And then your letters cost a couple dollars per letter, I think $2 per letter. So it's not real expensive. And if it's a DVAP case, you can file, I want to say it's an affidavit of no assets, but there's another name for it they give you so that you don't have to pay court costs. So that part should not be a problem for DVAP cases. I would say less than $500 for your paying clients. And then it's just what it costs for your time. Is the appraisal filed publicly or under seal? Okay, I'm glad you asked this. The inventory and appraisement. So it is a public document, although I think you can't get those if you go to the court's portal, you know, where you can pull up court records. So that I think is you can't just click on it, but you can go to the courthouse and get it. You can, if you have concerns, file an affidavit in lieu. So this makes the information not public, but it says, I have prepared an inventory and given it to all the beneficiaries. So you can do the affidavit in lieu, but you're still needing to go through the inventory, needing to give it to the people who would care most. then you can file an affidavit that says, I've done that, but you don't have, the assets aren't public knowledge. When is a small estate proceeding appropriate? So I am not, these are used for DVAP cases. I wouldn't use it for anything but a DVAP case. The courts don't like them. I think sometimes our courts say only if the spouse gets everything. Maybe it's if a kid gets everything. It's been a while since I've done one of those. I would not use it for an estate that has any significant assets at all. Or if they're paying you, the courts don't like them because you don't go through the same steps that you do for a regular probate. Sometimes it's what you need to do. And with DVAP, it can be a way to pass title. But DVAP is just about the only time I would use one of those. If the decedent has a transfer on death deed, which would transfer his home to his wife, does that get disclosed anywhere in the probate process? I don't see any reason it would. That is really a title. It makes it a non-probate asset. So assets, so bank accounts that have right of survivorship or pay on death are not considered probate assets and don't even go on an inventory. That transfers by way of the death, and that's it. It is no longer in the decedent's estate. So it can be a surprise to some beneficiaries when they look at the inventory and say, where's mom's house? But then they can go to the deed records and find that, oh, it was transferred by the deed. Should a person give copies of their will to beneficiaries? A lady died and had given copies of the will. You know, some people want to do that and they want to talk about it. I mean, certainly if you're going to do something crazy, the kind of cases that we fight about, yeah, if they've told people about it, that helps because maybe they've had a discussion. One problem comes though is they could change the will and then they don't give it to those people. Is that going to cause a problem later? I mean, it would just have to be explained, but people could think, oh, this is the last will, and then not know grandma's actually done 3 more wills. But it's good to have copies somewhere because if you lose the original, you want to be able to at least probate a copy and not have the person be intestate. If you're aware that your client intends to appoint an executor in their will who is disqualified, should you advise them not to appoint executor? Like I said, there aren't that many absolute bars. So it depends on how bad it is. I would advise them to appoint somebody else, but if they're insistent, what can you do? That person, you're going to have to disqualify the executor. Maybe they would sign a declination, which would make things easier, but if you have to attack them, then you're running into a problem. And it would be good to at least explain that to your client before appointing somebody that you say, this is just going to cause problems for everyone. I've heard there's an affidavit that can file in lieu of inventory. So I covered that. I don't commonly use it. I use it some, but if you're going to have to prepare the inventory anyway, if everybody's getting along, I'll tell my clients, if you're talking to everybody and y'all the whole time, then sure, because it can be a simpler inventory. But a lot of times I'm doing it anyway. So I don't worry that much about filing it in the public records. I don't think that many people are going down and looking, just trying to find inventories. I don't think there's any pitfalls as long as they actually give it to the beneficiaries. I've had cases where they didn't, and that's a problem later. Oh, good. Someone put in the link if you want it there. If the will has not been probated in 4 years, do the heirs at law have to agree to a muniment of title? No, they don't have to agree, but they could come and say why it should not be probated, that there wasn't a good reason, that the will was actually revoked, but they do not have to agree. They'll get notice of it, so it gives them an opportunity to come to the court and be heard. I'm trying to go a little quickly because I see where it's 1 o'clock. For DVAP cases, you can get court fees waived. How are other fees paid, such as publishing fees, published notice to creditors, copies of letters, etc.? I think that's all waived. I think once you file your affidavit, I know the copies of letters are, and I'm 99% sure the published notice to creditors, anything that's required to be done gets waived. Now fees in deed records do not get waived. That's separate, and they do have, as far as I know, they have to pay for that. What if the will is typed 2018 on signature page by person signing the will, but date is crossed out and hand printed 2020 and is notarized by notary for current date of 2020? Is will still good? You're probably going to want, it's going to be a discussion with the court. I can't say just offhand whether that's valid. Does it matter if it was 2018? If you go back to 2018, does that matter? Notary is not enough because the will has to be witnessed. If you make changes, you have to have it re-witnessed. So the notarizing doesn't really do anything. I just think that's going to be a conversation and kind of fact specific. So I can't really say. The link is not visible to all. It's https://dba-estatesmanual.com. dba-estatesmanual.com. If you Google Dallas Probate Manual, Dallas County Probate Manual, I think it'll pop up. I know there's some comments in the chat, but I don't really think there's time. If anybody has any questions, feel free to email me at Melinda@Hartnett Law Firm, which is HARTNETT lawfirm.com, and I'm happy to answer any questions you might have.